Yes, Mr. Mitchell.
Thank you, my lord. I was thinking now going to deal with ground 2.
Just before you
sorry,
do,
of course.
could I
Yes.
just raise with you one point? It relates to the question of the artificiality of a tax avoidance scheme, the debate we were having. Have you got the supplemental bundle there? I think it's well, it's okay. Yes, it's probably supplemental trial bundle 1, I think it is, and if you go to page 298. And just towards the foot at G, this is Mr. Bhaur being cross-examined. And it's put to him that what he's done is to buy a tax avoidance scheme. Isn't that right? Yes, it is. And looking over the page, saying it was complex, it's inevitable, isn't it? Yes, it is, because it's an artificial device, isn't it? Yes, it is. I mean, his evidence was he knew what he was buying was an artificial tax avoidance scheme. That's his evidence, isn't it?
So let me just check where we are, whether this
You go back, it's Mr. Bhaur Senior.
yes.
You can see that from page 294, right at the start of Mr. Ash's cross-examination. I mean, doesn't the bottom of 298 and top of 299 make it clear that what the Bhaurs knew they were buying was an artificial tax avoidance scheme?
The last line suggests what I know now.
Well, you see,
yes.
Yeah, he accepts.
I'm not sure that. I'm sure the answer is clear.
Well, it all starts at F.
Yes.
With the question, you were looking to avoid tax, weren't you? I wanted to minimise liability. So this is all looking at what he was wanting to do at the time.
At the time, yes.
And
at H, he explicitly says in his own answer, he volunteers what I know now and what I knew at the time.
It's a complex solution.
Yeah.
But the word avoidance was put to him by Mr. Ash. It's not his word.
Well, what's wrong with that? That's the purpose of cross-examination.
Yes, I understand that. But it's not necessary. But whether he knew what the word meant, because it goes on to it. Yes, I mean not. It's not necessarily illegal or anything like that. An avoidance scheme is something to avoid tax, which would otherwise be payable if you didn't enter into the scheme. Not that it's artificial. I think the point we were talking about before the lunch was the artificiality of it. He wanted to buy a scheme to avoid paying inheritance tax. That's what he thought he'd bought, or was hoping to buy.
well, okay. Well, in a similar vein, paragraph 82. Sorry, footnote 82 to the judgment. Do we have that email exchange, the 21st and 22nd of May 2007, anywhere in the bundles?
I think we do. I think it's referred to, of course, this is after the event, but I think we.
Yeah, I know.
Yes.
Not long after the event.
No.
But
this is I think this is a reference to the what I think was referred to as closing the file.
I don't.
Or is that because it's not?
No, I don't think it is.
Okay.
It's an email exchange, I don't think but I'd quite like to see it if I could.
No, I don't think it is referred to in the judgment. I certainly can find it in the papers and give it to your lordship if you would like to see it.
Yeah. Well, I'll hold fire on any questions until I do. But it's certainly. I think I certainly would like to see it because what the judge there refers to, in essence, is to the number of employees being tailored to fit the scheme and were not inherent in the Bhaur family or to the Bhaur family's business. In other words, the company was being shaped artificially to fit the requirements of the scheme. I mean,
after it had been, yes. Well, I think the point we make is.
Well, he complained. Mr. Bhaur complained that Aston Court had rather jumped the gun. I think had done some documents rather too fast, and then slightly after the event, they were trying to shape the number of employees they had to make sure they fitted the requirements of the scheme.
Yes, in
terms of whether they were family members or non-family members.
Yeah, there certainly were emails where ACC were encouraging the Bhaur family to have non-family member employees.
Well, it's exactly that email.
Which is, yes. Yeah.
So we have bits of the email set out by Mr. Bhaur in his witness statement. This is supplemental volume 2 at tab C at page 68. Paragraph 44 at the top of the page. And Mr. Bhaur says there, ACC well knew that when the trust was set up, we did not have employees. As an email on 22nd May 2007, Mr. O'Toole to me, and this is clearly what's being referred to by the judge, stated, quote, I confirm we would prefer you had 2 employees of the UK company who are wholly unconnected with you or any family member, please, because these payers will have to be on the PAYE scheme administered. That was in my reply to my email asking, furthermore, could you also clarify that we need 2 employees apart from the family working for the company? Or is it total employees on the PAYE?
I suspect there's some evidence in. I think that email was put to Mr. Bhaur in. I'd probably find you the reference if you wanted.
I can give you the reference if you want it. It's at page 3. It's just a little bit further on from the extracts we were looking at.
No, it would have been put. It would have been put to him on day 1, I suspect, by Mr. Anderson in chief. I think the passages you were looking at before was Mr. Ash's final. Bit we looked at a moment ago.
Well,
yes, but we can look at it both. But
okay. In fact, you'll see at page 311 of the transcript, just a little bit on from where I was looking before, you'll see that what's actually there put to, in fact, all of the Bhaur family, I think, who were giving evidence simultaneously at the time, but it's dealing with the witness statement of Mr. Bhaur Senior, I think, and you'll see that he's questioned about paragraph 42 and 33. 42 is the one that we've just seen in where my lord was taking you to in the witness statement, which said the taxation advice falsely asserts the company was concerned to build a commercial staff incentive vehicle to ensure the hard work of employees who make a contribution to the success of the business. As we did not have any employees and did not intend to have any, this was false. And I think Mr. Bhaur said, wait a minute, that's not perhaps quite right. There, he referred back to 33, where there is the reference to following a meeting, we set about employing an office manager and a maintenance manager, but before those staff members were employed, ACC proceeded to set up the trust structure. In all honesty, the speed with which they seemed to move and regurgitate advice was a lot quicker than we had expected. and I think he is asked about in that context, or he mentions in that context at the very foot of page 311 and the top of page 312, that somewhere I have an email from ACC telling me they prefer to have 2 employees, etc. So he seems to tie the two together because he goes a little bit further down. He says just below C, well, we were told by ACC we should have 2 2 employees, and then I was inquiring because they have to meet the requirement of some regulation, and I was inquiring if it could be already 2 of us there and my daughter-in-law, whether it's connected or unconnected. And he says, yes, I suppose it's this really. That requirement was to fit into the design of the tax avoidance scheme, wasn't it? He says, according to that, yes. But that was the package you bought, wasn't it? So it is all a piece, isn't it?
Yeah. But it's all that all this arose post signature. So this is post the mistake of entering into the scheme. So the question of the external employees, the non-family employees, arose for the first time of these emails in the months after the scheme.
But even after the scheme, nobody is saying, oh my goodness me, we bought a tax avoidance scheme. We didn't realise that. Or, oh my goodness me, why are we figuring out how many employees we can take on to fit the scheme? Goodness me, we never realised that.
But it's different to the question of benefit.
Well, it may be, but that's not the point I'm making. I'm just trying to tie up the ends which we were addressing before lunch on ground 1, where I put to you a number of times, why isn't this an artificial tax avoidance scheme which equity will not, even if there's a mistake, equity will not assist you to be relieved from it. And I think you before lunch were not really, you're pushing back about whether this was an artificial tax avoidance scheme, or certainly whether it was known to be an artificial tax avoidance scheme. And I'm just trying to put to you some points in the evidence and indeed the judgment which seem to suggest that it was indeed known to Bowers that it was an artificial tax avoidance scheme.
But not as at the date they entered into it. So, which is all I'm in.
Well, where's the evidence that their knowledge changed between the documents we've just been looking at, or had changed between when they entered into it and
because I think this is the shock of it. I think the emails themselves disclose the surprise at the point being raised.
So they don't say, goodness me, we've just bought an artificial tax avoidance scheme, we must unwind this immediately. They just carry on, and indeed.
But you have to see that the context of the emails in the context of the other dealings that are going on. Yes, but the point for the point.
So is there any evidence where they say we only discovered it was an artificial tax avoidance scheme in May, and we had no idea in March?
To the word art, I'm not sure what the word art. I'm troubled by the word artificial.
Well, I'm only using.
It's not. I don't think this is. This is saying for a scheme. This is saying we've sold you a scheme. It has greater prospects of on its face. It has greater prospects of satisfying HMRC if you have employees, external family employees, and therefore my clients deal with that question of employees. They have people around anyway. They employ somebody, I think was the evidence, after the scheme's been entered into. It's not artificial if they have an employee. The employee that they refer to is not it's not like there is a sense suggested by Mr. O'Toole on the third trust, an employee that doesn't actually exist. The employees they put forward are people who are actually employed, who have wages, who are on the staff and perform real duties and obligations for the company. So they shape. So in that regard, they're simply shaping their business at the instigation of ACC, at the suggestion of ACC, to give the scheme a better chance of success. But it's against that background. Their knowledge is de minimis at this point.
So let me just write that down. So you're shaping the company, or the company's business, is this right? Or its employee workforce.
An employee, yes.
give the scheme a better chance of success,
That's what they thought they were doing.
not for any commercial purpose.
Well, but it has a commercial purpose. That employee is going to do some work. There's a task that has to be performed. There's nothing artificial about structuring your business so that it has a secondary or another advantage to doing it in that way. It can be done by Mr. A or Mr. B. If Mr. B, doing it that way, is told by your solicitor on the scheme they've just sold you, gives it better prospects of the revenue, accepting it, in circumstances where the judge rightly found my clients had no real understanding of what the underlying tax position was or the tax law. They just did what they're not told, but what they were advised to do. I think that's artificial. The artificiality would be if that employee had no job to do. If it was Mr. Smith, he was put on the payroll, Mr. Smith did nothing. He didn't. He was simply an artificial employee. The position, the evidence suggests that these people who they told ACC about were put on the payroll and performed tasks for the company, work that had to be done. They arranged the company's affairs so as to what they thought was to match the scheme that they had been sold. Such is misplaced, I accept that, but that's all that's happening here.
At some point, I don't want to delay us going on to the other grounds, but at some point, can you give me the references to the evidence you say makes that good?
Okay, I shall try. Just take a note, Tess, I should forget.
So you say the judge is wrong when he says that the employees were not inherent to the Bhaur family's business?
I'm not sure what the word inherent means. They clearly could operate it without those employees, but doesn't mean that if they do operate it with those employees, that is in any way improper. That's the point I'm making. Is that the distinction I seek to draw is between a fake employee or somebody who's on the payroll who's not performing any useful, isn't working for the company, has no job to do, but is simply there so that it can be suggested to the revenue that there is an employee. With that, contrasting that with what actually happened in this case, which was that ACC said the scheme works better if you've got some external employees, and so the boards recruited somebody, and paid them a salary, and they worked for the business. They did the job description for which they were engaged to do. I accept that the board never intended that person to have any significant benefit from the trust. I accept that point. But there's a different point to the mere employment of the employee.
Yes.
Right, thank you.
Right, we're going to move on to ground two.
I should move on to ground two. So ground two is found, the grounds of appeal are found in the first bundle. It's probably worth just reading them. Page 14 in the first bundle. And so ground two is the judge rejected the claimant's case that they did not know the scheme was unsuitable for them, making a factual finding that the claimant signed documents containing false statements in order to dupe HMRC. And the references to the judgment there, I think, are all passages that we've looked at this morning. 3131. I think we've looked at that this morning. So we make 2 points. The first one is that this point was not put to the Bhaurs in cross-examination. So this is the point as at the position at 17th March. and the fact that they had, in particular, that they had signed documents containing false statements in order to dupe HMRC. Now, given that the judge accepted the evidence of the Bhaur family, the judge is very clear, in particular at paragraph 215 of his judgment, to say that he accepted the evidence of the Bhaurs, and actually not just accept, but that the evidence was given honestly with a clear desire to assist the court.
Well, there are 2 points here,
Yes.
aren't there? One is not putting cross-examination, and the other is, in effect, inconsistent findings.
Yes.
Where there's only one party represented before the court, what's the judge to do? Does he have to accept everything that the represented party says?
No, that's the point. Is that it was fully open to the judge to say he didn't believe the Bhaurs. I'm sorry. The starting proposition in this case is the judge accepted the evidence given by the Bhaurs.
That's why I'm trying to separate the 2 points.
Yes.
I mean, it wouldn't be appropriate, would it, for the judge to cross-examine the Bhaurs? He's the judge, not the opponent.
In this case, the judge produced a list of questions for Mr. Ash to put.
Is this the red flags document?
Yes, there was a red flag document and then some other points also during the trial. So it was identified the important bits that should be put to the clients. And also, the judge, firstly, and secondly, the judge also did put if you look at the transcripts, fairly often, he put points to Mr. Bhaur.
Do we have those 2 documents that the judge produced?
And we haven't got them in the bundle. They are, the main red flag document is recited by us in our closing submissions. So there's a section in the closing submissions which says...
Is that the one that's under the heading, Claimants' Participation in the Masquerade by Signing Misleading Documents?
So where's your lordship looking at?
I'm looking at Supplemental Volume 2, page 100. This is your...
No, the red flags heading, you can...
Okay, well, let me just stick with the one I've just mentioned then. Because doesn't that indicate, even from the heading, never mind what follows, that by closing, you were well aware, or the bar's representatives were well aware, that one of the points that was of concern to the court, and you see that from page 98, if you turn back a page, it's the court's areas of concern, that one of the court's areas of concern was the claimants participated in the masquerade by signing misleading documents.
Yeah.
In other words, they were well aware that it was on the cards that the judge was thinking that the claimants had been complicit in the masquerade.
But sorry.
And that's why I'm interested in seeing how the judge actually put it. But what more does the judge need to do to bring it to the attention of your side that that's what's on his mind, so that if necessary you can say, well, wait a minute, that was never put in the course of evidence in this rather strange procedure that was adopted. It really should be.
It's the duping of HMRC that's the point. That's the focus of this ground.
What? In the masquerade by signing misleading documents? What's
to mislead HMRC? That's the point. That's the finding the judge makes adverse to us.
What other purpose would there be in participating in a masquerade?
Well, the judge considers whenever properly resolves in his judgment the 2 reasons for this. One could be between ACC and the board, so it could be a plan. These documents can be then deliberately placed by ACC to protect themselves against a claim by the Bhaurs. That's one option. Or the other option is that they're in it together.
Yep.
And the judge appears without... and if they're in it together and it's there to dupe HMRC, then that's dishonest.
Yes, but
Judge finds we weren't.
Your complaint is that the judge, as it were, it wasn't put to your clients that they were in it to dupe HMRC. And I'm pointing out that it certainly seems to have been understood in the closing that one of the things that the judge was concerned about was that your clients were participating in a masquerade, participating in a masquerade, but that can only mean with Aston Court, and the only person who's going to be misled by the documents that is signed, just in that title, is HMRC. I mean, how much clearer does it need to be?
But then the issue is that the evidence isn't there to, sorry, it's unfair to, maybe it's an unfairness in the process, but the unfairness is that the judge accepts the evidence that the Bhaurs give, but they haven't got the opportunity to give a direct answer to the direct point. Now, it might be thought, well, that's my fault for not but I can't ask the point of it, not asking an open question to my witness. But I think that would be unfair.
Surely, I mean, what should have happened in this rather unusual case where cross-examination didn't take a normal course is that if you get wind that the judge is thinking about making a finding like that, you would, in the normal course of events, you'd say it's not open to the judge to make the finding because my opponent didn't put it to my witness. But where there is no opponent to put it to your witness and the trial's proceeded the way it is, surely you'd say to the judge, this is unfair as a matter of process. You can't make that finding because the question wasn't put to the witness. And inevitably, I imagine what the judge might say, well, in the circumstances, it had better be put so I can hear his answer.
I think the point is that wider point was put, but the narrower point wasn't. I think that's the best I can, in other words, as to the state of mind in March 07 as opposed to more generally. And of course the bulk of the document, the large number of the documents are post-March documents.
So is this a timing point?
Well, I think maybe the focus came down, yes.
I'm struggling to see why the claimants signed documents which dress the scheme up as something different from reality for the purpose of protecting ACC against the claim. I just don't follow that.
But they represented I think take you where the judge identifies the two possibilities. But it is that they presented them without my clients having any great notice of them. I think the evidence suggests they kept the intellectual property rights themselves and wouldn't leave paperwork with us. And my clients were presented with documents that said clearly what they say. One option is that
the documents were created for the purpose of showing them to HMRC to get the tax relief that the Bhaurs wanted to get.
Yes. And
how could they not have known that these documents, which dress the scheme up as something different from reality, were not going to be shown to HMRC?
But it's the dressed up reality point that where I'm part. So clearly they signed them and they knew that they'd be presented to HMRC. Right. I accept that. The real question is that the nub of the challenge is the Bhaurs understanding that that's what it was. That's what it did.
What, dressed it up as something it wasn't?
Yes.
So they thought that the documents they signed reflected the reality?
That they trusted their solicitor who drafted the documents that they reflected the reality. So they employed a solicitor to carry out this transaction for them. They're entitled to trust the ability, the honesty and the integrity of that solicitor. Their evidence was that Mr. Bhaur's evidence was they asked the solicitor about it and were reassured. So,
right.
That's the point. And you can see in the closing submissions it's grappled with the heading that Lord Snowden referred you to then deals with how that matter was closed.
Yes.
And so you can see that and you can see the judges, in a sense, the judge heard the Bhaurs give their evidence, and you can see a paragraph in the closing submissions. We emphasise in the judgment the fact that the Bhaurs were accepted. That they read the documents that were put in front of them for signature.
This is only a process point. Sorry.
Yeah,
This ground ground
Yes.
2 is a process point, a fairness point.
Yes.
No fair opportunity to deal with the suggestion that the Bhaurs signed false documents in order to dupe HMRC, and that was their state of mind on the 17th of March 2007. So it's only a question of, as I understood it, this was a suggestion that the first you knew about this finding was when it appeared sort of in the draft judgment, and you'd had no chance to deal with it in evidence or otherwise, and the judge deprived you of that. And I'm saying, well, how can that be when in the document which we haven't got, but which I would like to see, or indeed 2 documents, they were plainly understood by those advising the Bhaurs to raise a concern that the claimants had participated in the masquerade by signing misleading documents, which were obviously designed to couldn't mislead anybody other than HMRC. There was no other candidate to mislead.
Yes. I think the point that we're making in the grounds of appeal is the fact that that's a dishonesty finding, and that wasn't put to them that they were dishonest. That's what it is. If you put it forward to dupe HMRC, that appears to be an express finding.
But as my lord put to you, that's actually an inconsistency. Isn't it? The judge said, in one hand, I accept them as honest witnesses, and on the other hand, he makes a finding which you say is synonymous with dishonesty. But the core of the allegation, whether you attach the label dishonesty to it or not, is clearly identified. You participated in a masquerade by signing misleading documents. I'm just reading the title.
Yes, and I've accepted that wasn't put to them. It should have been. They should have. The procedural point is still a good point. Now, whether it's the reason it happened is a separate matter. But the starting proposition is: was it put to them? Answer: no. In evidence, did they have a chance to express the answer in evidence? Answer: no. The subsequent to that is, well, we have this trial process where there is no proper cross-examination. Why is that not happened? My Lord Snowden suggests, well, there's an additional burden on the claimants' lawyers to ask some question in chief in order to elicit it, because there was thought that this question might be around. But that we said that's not an answer to the difficulty with it. In that the practical point is they didn't have the opportunity. They were not asked the question straight, Mr. Bhaur, and so the court did not have his evidence on this crucial point as to whether he was dishonest. That's really it's an introductory point.
That's the process point.
Yes.
Can I just ask you a little bit about the inconsistency point? Suppose the Bhaurs had been asked,
yes,
and it was put to them, you, the Bhaurs, signed these documents knowing that they were a masquerade concealing the reality, and you knew that they were going to be shown to HMRC. And Mr. Bhaur said, yes, that's exactly what happened. It would be open to the judge to say, well, they were honest witnesses, but at the time, they were engaged in this masquerade. In other words, the fact that somebody gives their evidence honestly, which is what the judge found, doesn't necessarily mean that everything they did was honest.
yes.
And my Lord Justice Snowden has shown you passages in Mr. Bhaur's evidence in which he accepted that this was an artificial tax avoidance scheme. Now that's honest.
But yes. But the point about it is that Mr. Bhaur had an explanation as to what it was put in the closing and other questions in his evidence, his explanation as to why he signed the documents and why it did not put him on notice that there was a problem. That was his evidence that hasn't got to the judgment, we say, and this is the sort of twin track of employee benefit. He thought he was employee, and he had honest lawyers who told him it was lawful and legal and were advising him. Those are the sort of the twin track, both of which haven't got their way to the judgment, and both of which we say are in large measure the answer, the explanation for that point. So yes, Your Lordship this morning was looking at the director's resolution. You know, we accept that's why that paragraph's in the closing submission. It wasn't something that we shy away from, but Mr. Bhaur gave his evidence and we closed it as to why that wasn't, why he did not have the subjective knowledge that this was, that he was entering into something that was a mistake, that didn't do what he wanted it to do, and that was unsuitable for him. And we say it has to be seen against the background of his knowledge, and then at that stage, you know, they were, you know, this isn't a consumer context, but you might think, from, you know, they're naive consumers, really, in this. This was missold to them. And the judge found that they'd entered into, you know, they'd instructed rogues who took advantage of them. Now, yeah. whether we need to go that far to deal with the appeal, but that's why it's important, we say, to look at the position up to March 2007, because it's very, very early on in this, and they had, you know, developed the grounds. But the point being, they'd engaged with what on their face looked to be competent and honest solicitors. And there was no reason at the outset, there's no flag given to them as to why they shouldn't start by trusting these apparently competent solicitors to give them advice. Yeah. And those solicitors did give them advice. Now, there might well have come a time during the 13 years when they had good reason to think that these were no longer competent or honest solicitors. But the key question for the judge on the way he dealt with the judgment is whether that point had been reached by the middle of March 2007, 17th of March. That's the question again. It's one of our grounds of appeal that the judge didn't deal with, because he seems to accept that Mr. Bhaur relied upon them as honest and competent solicitors, and he didn't. And we say there's no reason why that confidence should have been, on the evidence that was given, lost by the time of the 17th of March. It could or could not have been the position there afterwards. That's a different point. I don't know whether you want me to take you. I mean, I think I've highlighted nearly most of the points from the second and third ground. I can take you to the evidence that's there. I imagine you know the evidence from Mr. Bhaur is pretty clear on the.
Well, I would quite like you to go to at least some of the evidence. I mean, if we're moving off the process point.
Yes.
I mean, the. Well, I mean, are you going to come to look in some slightly more detail, for example, at the transcripts which you refer to in paragraphs, say, 40 through to 45 of your skeleton? Or have you done that?
No, yes, I'm very happy to take it.
Is that to come?
That's to come, yes.
Okay, sorry, I've lost the thread of which grounds we were on.
Well, so I'm trying to do it in the the skeleton's split up. We've done the first. I think we've done the first part of ground 2,
okay.
Which is that it wasn't put. I think naturally then the third. We then move on to the third ground, which is did not deal with our case. That they believe that Mr. Bhaur believed Aston Court to be honest solicitors, and signed the false documents in reliance upon the trust they placed in them as such.
Were we skipping over 2.2?
Oh, well, we dealt in my skeleton. I deal with 2. We think this one goes first, and then we come back to 2.2. I'm happy to deal with 2.2.
Yes.
First, if you want. I was doing the
No,
order.
you
Yes,
take it.
I'll certainly come back to 2.2. I wasn't leaving it out. So ground 3, which is a point that we've we've opened it at some length, but it's important that. So it's, the starting point then, of course, of ground 3 does come to the fact that the judge found that Mr. O'Toole was dishonest. Not only generally, but also what he told the Bhaurs about the scheme prior to the 17th of March. Now, whether it's dishonest or not, in a sense, it's going to the state of mind, at this point, to the state of mind of the Bhaurs. So I'm not sure we need to even emphasise the dishonesty point of it, but the point is that the background to it is that the judge certainly found that ACC wanted to, they were selling a scheme that shouldn't have been sold to the Bhaurs, and that ACC acted, that he went as high as to say it acted dishonestly in that grounds. But the judge proceeded on the basis of that of paragraph 180 of his judgment, and then goes on at paragraph 210, again to say that the scheme was oversold by ACC. And he relies in that regard upon the contents of the Wealth Management Report, which is the December document that we've gone to, and that he finds that the document itself makes statements and fails to disclose risk in a manner the judge found was indefensible. And he finds that those statements and failures to disclose were not just negligent or incompetent, but they were knowingly done or admitted to be done by Aston Court, and he finds that that was dishonest.
Right. So the bottom line is, as you identify in your paragraphs 34 and 35, and as we were talking about this morning,
Yes.
you say that there was a mistake as to the character of Mr. O'Toole. The Bhaurs thought that they were dealing with an honest person, and in reality they were dealing with a rogue.
Yes.
So anybody who deals with someone who they believe to be honest but turns out not to be, or indeed is not, as you rightly say, you don't even have to go that far. If you believe them to be competent and they turn out to be incompetent, you can have it set aside.
Yeah, but this point is an attack on the finding that, in essence, that the boards were not entitled to rely upon the advice given by ACC. So they had no reason whatsoever to disbelieve the advice that they were being given by their solicitors at this point in time.
That doesn't seem to be the submission you're making in your written submissions, because what you say there, and I well understand the way you put it in writing, is you say the claimants were mistaken as to the character of Mr. O'Toole ACC. This clear mistake was pleaded as a self-standing operative mistake in the points to claim and was advanced in the claimant's written closing submissions under a separate heading, as we saw this morning. But you're quite right about that. But the judge made no finding about it.
Yes.
So the complaint you're articulating in the skeleton is to say, here was a pleaded case of mistake as to the character of Mr. O'Toole. Judge made no finding.
Yes, and should have done. But he, yes. Well, he
But
made no
the
finding.
question I'm asking for you is, assume you're right that the judge failed to make a finding on a point he should have made. So let's take that. What's the legal consequence? So suppose that he should have made a finding that your clients were mistaken as to the character of Mr. O'Toole. Suppose they were mistaken about the character of Mr. O'Toole. What's the legal consequence?
Well, there were two. It goes to ground 3 and to ground 4. So I was trying to address. So it's more important on ground 4 because of the trustee position, the ceding of control to the rogue. That's ground 4. But ground 3 goes to the point, which is their belief that they were dealing with an honest solicitor, which then colours or means they're entitled to rely upon the advice that they are receiving. So they did not know that he was, that the advice they were giving was dishonest. The judge found that.
Why is it different if it's negligent? Or do you say that the result is exactly the same if it's negligent?
And we say this is the reason why the judge should not have found that we were party to the dupe, because we say we
That's
followed.
a different point. So I'm trying to explore the
sorry.
legal consequences of the argument you've advanced in writing. And it seems to have some foundation as a premise. You say, judge didn't make a finding, we had a case, he should have made a finding, he should have found we were mistaken as to the character.
Yes.
And I say, okay, let's assume all of that's correct.
Yes.
What's the consequence?
But that's a mistake as to his
But
character.
why? Why? Why is that a legally relevant mistake? Suppose I deal, as I say, with a solicitor. My belief is not merely that he's honest, but he's competent. It turns out he's honest but incompetent. What's the difference?
It's this context, which is a voluntary disposition. So if you're selling a house, then of course that isn't relevant. You have your negligence claim against it. In this case, in this jurisdiction that we're seeking to operate in, which is to set aside a voluntary disposition.
If you're advised by a solicitor in relation to a voluntary disposition, you've got a negligence claim as well.
Yes, but the court will also grant the mistake claim. Nearly all these mistake claims are claims where a solicitor has given negligent advice and the courts relieve the innocent party of the problem.
Right. So your answer to my question is straightforward. You say the character of the mistake as to whether the mistake is to character goes to honesty or competence doesn't matter. Either is sufficient, you say.
Yes.
Why does... I'm struggling to understand at the moment how the honesty of your advisor in general terms is a mistake either as to the legal character or nature of the transaction or as to some matter of fact or law which is basic to the transaction. What can you be specific? What's specific to the transaction?
Well, we didn't know what we were we did not know what we were entering into, the standard mistake argument. So the points we made.
Well, you knew it.
No,
the argument.
But also as to the documents we were signing. So the documents that are put again in circular. The points the minutes of the directors' meetings that are put to us that we signed, which are inconsistent with our instructions. Those documents that we entered them into a mistake, the same mistake point, based upon the fact they were put in front of us by a solicitor who we thought was honest and was acting in our best interest, and that they recorded our wishes and implemented the instructions that had been given to the solicitor originally.
But can I pursue the question I was asking you earlier? Because I think where we got to is your submission is that a mistake as to the character of the advisor is sufficient to have a voluntary disposition set aside, whether the mistake is as to their honesty or as to their competence. But let's take the example of competence. So the advisor gives negligent advice. Why is not the relevant question, legally speaking, what the advice given was and whether there was a mistake as to the consequences of the advice? In other words, the flaw is in the advice, not in the character of the person giving it. That's what's legally important. Would you accept that or dispute that? So it's about the content of the advice, not about the personality of the person who gives it.
My client accepted the advice because he thought it was given by an honest solicitor. That coloured his decision to accept
Well,
it.
presumably he wouldn't have accepted it if he thought the solicitor was dishonest, but nor would he have accepted it if he thought the solicitor was incompetent. I mean, it's inherent in this kind of scenario. The client always believes that the solicitor is honest and competent. But let's suppose, for example, that the facts were that Mr. O'Toole had been 100% honest and 100% competent in his dealings with the Bhaurs, but he dishonestly stolen £1 million from some unrelated party. Is that a basis for getting this transaction set aside?
But it has to be added to a problem with the transaction itself.
So it has to be causative.
Yeah.
Right. But doesn't that tell you that what matters is not the character of the person, but the nature of the advice?
Yes, I would accept that. But the point, but it comes back on other points in the appeal. Ground 4, ceded control comes to. It also comes to the factual question of whether my client was entitled to accept the advice he was given, and therefore, and when he signed documents, that was not done dishonestly, because he was entitled to say I have a competent and honest solicitor. And when I read the documents, which is need to look at the evidence. I made the point before. When I looked at the documents and I had concerns, I asked my solicitor whether this was lawful and was entitled to accept his reassurance.
Yes.
So there are references in so the first set of references in paragraph 33 of the transcript goes to the reliance placed on Mr. Bhaur on the fact that Mr. O'Toole was a solicitor. I don't know whether you want me to take you to those, but paragraph 33 of the skeleton. But my Lord Arnold made the point that we want to make is that solicitors, it's normal for clients to accept the advice given to them by their solicitors. Should be the starting point. And the judge found that the Bhaurs found HCC to be both expert and respectable. I think this then comes back to the second part of ground 2, which is that the second part is that the claimants gave evidence to the opposite. So this is as to the finding that the claimant signed documents containing false statements in order to dupe HMRC. We've dealt with the procedural point. The second point is the first claimant gave evidence to the opposite effect, and the starting point for that is paragraph 216 of the judgment. So this is what might be called the operative part of the judgment. He says, nevertheless, given where the judge appears to rely solely on their subjective statements as to their state of mind. So paragraph 216, nevertheless, given their subjective statements as to the state of mind as much weight as I do, I'm firmly of the conclusion that the Bhaur family in general, Mr. Bhaur in particular, were not mistaken at the time they signed up to the scheme. So what the judge appears to be relying upon here is subjective statements and overlooked the evidence that had been given by Mr. Bhaur of what he actually did.
No, wait a minute. That's not.
Yeah, well.
Wait a minute. Wait a minute. Look at 215. What there is, the judge is saying, is he records that in the middle of paragraph 215 that the Bhaur family made assertions in the pleadings and in their evidence, written and oral, that they were mistaken.
Yes.
And he's saying, in other words, that was their belief that they were mistaken in entering into the scheme. And he says that is entitled to great weight, particularly given, as I found it, dishonest conduct of Aston Court. And then he says, nevertheless, giving their subjective statements as to their state of mind as much weight as I do. In other words, I am giving their evidence and their assertions that they were mistaken as much weight as I can. I am firmly of the conclusion that they were not mistaken. In other words, he has taken into account their subjective statements. I'm struggling to...
But the fact that they said, we read the documents, I asked my solicitor whether this was lawful and he said it was. It's not subjective. That isn't subjective.
I don't think that's what he's dealing with. I think he's dealing with something quite different in that,
Okay.
that particular part. He then goes on to give
The reasons.
far more elaborate reasons.
In any event, this goes to the question we were discussing this morning. This is why all these points are interrelated, which is the problem is not lawfulness, the problem is artificial avoidance, and unsuccessful at that.
Firstly, and secondly, a loss of, we haven't got to ground 4 yet. There's a problem with the lack of control, the loss of control, the actual loss of control, which the judge again doesn't deal with. Yes, I accept, and that's maybe why, in one way, the skeleton jumps from ground 2 to ground 3 and back again is because the point is really the same point looked at from different sides.
Well, the judge was very clear about lack of control. He said there was no mistake at all.
But only on the basis that, sorry, can I deal with ground 4 when I get there? I'll try and get there as fast as as I can. But the point that we're continue to look through 216, 217, what the judge finds at 2172. So he starts with the critical questions, and this is then dealing with what he called papering the file and the documents that, in particular, my Lord Lewison had in mind this morning, what could be called window dressing. And he finds that this window dressing done in order to dupe HMRC with the Bhaur family's tacit assent. He says, my conclusion on this critical point is he finds that it was done in order to dupe HMRC with the Bhaur family's tacit assent, and that's the challenge. And then he sets out below at A and B the basis of to why he's found that. So subparagraph A is effectively an introduction. Accepts the evidence that Mr. Bhaur and his sons read documents considered points. Documents are read, points considered, issues evaluated. In part, though, that's looking at his evidence going back over the 13 years. I think the evidence was that the initial phase was that Mr. Bhaur took the lead, although his sons were involved. Then he goes, we're talking about prudent, careful individuals who were considered Aston Court's proposal with attention and detail. That is all the more the case given the very large fee Aston Court were charging. The Bhaur family would have wanted to know what they were getting and would have probed, it's the probe point, accordingly. I accept the Bhaur family would have considered Aston Court both expert and respectable, and would have placed weight on the fact that Mr. O'Toole was a solicitor.
You don't need to read this out,
Okay,
Mr.
yes.
Mitchell, just make the points.
Yes, so trying to get to the point at the bottom is, but conversely, if Aston Court said as they did that they, Aston Court, were relying on the Bhaur family for information, then that is something the Bhaur family would and should have taken seriously. Equally, where Aston Court now appears to be big an area regarding the Bhaur's family intentions.
Yeah.
Yeah. So this is.
But the point you're making, as I understand it, it really comes out. The crux of it is at the foot of page 81 of the judgment, 128, I think it is in the bundle, and this is little c, little Roman 2, right at the foot of the page. What is important for the purpose of this case is they were not mistaken as the essential tax evasiveness of the scheme. Scheme was an employee remuneration trust and form only. The Bhaur family knew and endorsed this approach. Yes. And as I understand it, your complaint is a very simple one. Namely, it wasn't your case that what was wrong with this scheme was that it was unlawful tax evasion, still less, therefore, that you could possibly be knowingly participating in that. Your case was that this was lawful tax avoidance, not evasion, quite different, and that you were mistaken as to the downside and as to the character and as to the control. So there's a mismatch between the way the judges approach it and what your actual case was. Now, I understand all of that. That's all pretty clear to me. But what I find more difficult to understand is that if you frame the question correctly, why is not the answer, substance of the answer the same? Namely, your case was not this was tax evasion, this was tax avoidance, but your clients did know that. And so therefore, although the analysis in terms of evasion is wrong, because that wasn't your case, and the judge has gone off onto a frolic of his own to that extent, if you reframe it in the correct way, actually the answer is the same.
But we've had the ground one appeal as to the mistake in that regard. So we put
Yeah.
that one to one side. We then have the second ground, the second issues about it, which is the lack of control, and which ties in with the character of the effectively the trustees.
Well,
that
the
they'll
judge
pass- yeah.
makes a finding about lack of control at C Roman 1, also on page 81 of the judgment, page 128 on a bundle. And he founds the board knew that control was being removed.
Yes.
So your proposition must be, I think, that if I decide to set up a trust into which I put trust funds, and my trustee turns out to be dishonest, which I didn't know, not only have I got a claim against the trustee, but I can undo the trust.
When they're tied up, and what they because it was sold to them in the wealth management report, is actually would improve their control of assets. That's what the
That's a
wealth
different
management.
point. You're talking about the dishonesty,
Yeah.
or you say, of Mr. O'Toole. So
Yes.
it would seem to follow that if the trustee that is appointed is dishonest, then the trust can be unwound, which is quite a far-reaching proposition.
And it's not a finding that I invite your lordship to make. In this case, the point is tied to it's a claim for mistake, and it's a voluntary disposition induced, or the mistake is at the heart of the case. So this was Mr. O'Toole who sold the policy or the product or the scheme to the boards, and he told them when he sold it to them that they would that in essence they would keep control, not legal control, but that they would have control by reason of his involvement and ACC's involvement. Running right to the end, the board certainly didn't know that 13 years down the line that their assets could be pointed out to a charity. They didn't know that.
Well, it weren't their assets.
That they were assets before they put them into the trust. At the point they put them
That's
into,
precisely the point, though.
yes. But
I mean,
that
they did understand. I mean, you'll have to make this good on some evidence somewhere, or where the judge deals with it. Are you saying that they didn't understand that if assets are held by a trust or put into, are disposed of to trustees to hold on trust, that they are no longer under the control of the original owners?
that they knew the basic. We didn't put it that they didn't know the basic concepts of a trust, so that they were no longer the legal owners of the assets,
Right.
and that there were trustees who were not them who could make decisions about those assets.
So this is the old chestnut of you're prepared to put assets into the control of a trustee who promises to be, or you believe to be compliant, and will just do what you ask him to do and not exercise any sort of independent judgment. Is that it?
Yeah, well, and so not quite that high, but those sorts of concepts, yes. That the trustee was a friendly trustee who would act in being one and the same, would act in accordance with the intentions of the family when they set up the trust. Mr. O'Toole knew what the intentions were. He sold it on the basis that this was a dynastic 100-year family trust, and that would be how he would operate it, or ACC would operate it.
And is the evidence that that was not the case at the start? I mean, we know that at the end, assets went out in a direction that the Bhaur family were not happy with.
Yes.
But is there evidence that right from the off, Mr. O'Toole was up to no good? Was an inappropriate trustee, or what? I don't understand this. I don't really understand what the mistake, as at the 17th of March 2007, about Mr. O'Toole's willingness to do what was asked of him was.
And I think you've told us that income which the trust received was used in buying more properties which were in turn put into the trust,
Yes.
which is what the Bhaur family wanted. Sounds like.
Yes. No, but yes, they had no intention of drawing, certainly in the short term, short and medium term, drawing any.
So to start with, as my Lord Justice Snowden says, everything seemed to be going exactly as they wanted.
Yes and no. Yeah, sorry, I think that there were a number of
the administration.
The administration wasn't good, and there were problems. But we say that's not a mistake. We don't rely upon that as a mistake, and the judge deals with that in his judgment. Unfairly, it was a problem, but it's not a problem that we say we're mistaken about. The judge finds at paragraph 34. So this is when the scheme was being sold to Mr. Bhaur. So it was clear that the scheme being proposed met Mr. Bhaur's dual objective of avoiding the incidence of IHT for generations while maintaining his family's control over the assets transferred into the trust.
Sorry, paragraph 34.
135, sorry.
Oh, 13.
Sorry, it's my fault. And that's based upon.
Yes.
Yeah, and then that finding comes out of a sentence of paragraph 3.2 of the Wealth Management Report. So if you go back a page to paragraph 132 of the judgment, this is the original Wealth Management Report. It says a secondary but important aspect of these solutions is the personal control that you either retain or indeed in some cases the personal control that you actually obtain in relation to these funds.
Yeah.
So the scheme was sold to them on that basis that the scheme would, and the judge found at 135, met their objectives of IHT, avoiding incident of IHT, whilst maintaining family's control of the assets transferred to the trust.
Yes.
Now, the method by which those assets, that control would be given, Mr. Bhaur, it was simply the trust on ACC. They understood that the assets would, the lease and transferring it from their names to a third party. But their intention in doing that was that would allow them, because that's what ACC told them, to maintain their control over those assets.
So the control that they thought they were getting was that the person administering the trust would do what he was told, or would do something that was in their interests.
Well, according to the letter of wishes, yes, with the base, yes, being
And,
one of them.
and so,
Sorry.
I come back to my question: why was that a mistake, as at the 17th of March 2007? What's the evidence to suggest that wasn't what Mr. O'Toole would be minded to do as of 2007?
Well, we would say you either are dishonest or you're not. So it's a character trait rather than a point in time. Sorry.
Yeah, I think juries would be seriously misled if they got that direction from a child judge.
Well, he had. What we would say, he showed his true colours. Maybe that's a better phrase of looking at it. But he gave the impression of being loyal. He sold it to us and that would act in that way. And clearly, he didn't.
Well, he was until HMRC got onto him.
Yes.
But are you saying but it's...
Yeah.
Are you saying that he never had the intention, i.e. the mistake was operative at the start? In other words, he never intended to operate in your interests?
Well, we don't know.
But you focus for all the rest of the case very
on the beginning, I think.
clearly at the beginning. What you seem to be now doing is saying, well, it all turned out rather badly, and we now know, through what later happened once HMRC got on to Mr. O'Toole, that Mr. O'Toole did a number of things which he shouldn't have done. And therefore, ergo, you say, well, his true colours are, that's what he must have been like at the start, ergo, it's a mistake.
And the judge has made findings about his dishonesty at the point of sale of the policy, so I rely upon that. The judge found that it was dishonestly sold to us. I accept your lordship's about that finding.
Yeah.
I have concerns about that, but there are a number of findings he made about him, about ACC's conduct prior to March, that they find that it was dishonestly sold.
So, I mean, would
So-
you take it away from the facts? Would you accept that if you put your assets in, you settle your assets voluntarily on trust, handed over to a trust co for the benefit of children, and everything goes well for a while, but at some point the trustee or some employee of the trust co, whatever, encounters personal financial difficulties and decides to misappropriate trust assets, that you've got no claim in mistake.
I accept that. Yes. Has to be something have to be mistaken about something that exists as at the date of March. I accept I have to be mistaken about something at March 2007. They can't be mistaken about something in the future. I accept that. But the board's further issues, of course, is that they were entirely unaware that it could be appointed. Sorry.
But this lack of control,
Yeah.
what have you got to point to as at March 2007, which suggests that Mr. O'Toole never intended to give you control, or act in accordance with your wishes? He may have been dishonest in other respects. He may have been entirely keen to mislead the revenue, but that's not what you're complaining about. In this head, you're complaining about loss of control. So where's the evidence at all, never mind judicial findings, as to Mr. O'Toole's intentions not to do what you anticipated as at March 2007?
Nothing to that point. The 2 points you make are that we put it in the control of a rogue. He was a rogue.
Well, was he a rogue?
The judge found he was.
Was he a rogue? No. Was he a rogue in the material respect? You can't just say he was a rogue in the sense that he may have been a rogue, let's say, because he intends to mislead the revenue. But that's not the same loss of control which you're complaining about, as I understand it.
No, but we have given it to somebody who has that characteristic. We've given control of our assets to a rogue who might well, at the beginning of it, act in a way that's entirely appropriate, if that's the right phrase. But he has a greater propensity for rogueness, such that when the chips are down, he acts as he did in 16, 17, 18. When the revenue come knocking, he acts in an inappropriate way. That's a characteristic that existed as at March 2007. Might not have manifested itself for a while, but it was a characteristic of this of ACC and Mr. O'Toole.
How do we know any more than in the example that I gave you of somebody who runs into personal financial difficulties later? I mean, the revenue are knocking on his door because of his peddling of, as they see it, evasive schemes. They're not knocking on his door because he doesn't do his best for his clients.
Well, maybe. Sorry, there's an issue with that because
where's the evidence?
There was evidence given about the way in which he dealt with. Sorry, it didn't get its way to the judgment, but there's evidence about fees and the way he dealt with money. And that's actually what the
But you're talking of lack of control, Mr. Mitchell.
Yes.
So we need to focus on that. And the judge did make some findings about all that. I think it was 168 and following.
Similarly. Oh, I didn't hear the reference. I apologise.
I think it was 168. No, I'm sorry, I've got the wrong reference. It's 179 and following.
17.
Where he, under the heading control, he deals with it.
Yes.
And that takes you through to at least 190, perhaps a bit further. And nothing seems to go wrong in that respect until 2015.
Yes.
But after 2015.
But that's the going wrong, I suppose. So the die was cast in March 2007 when it was when it was set up. And
then what, in answer to my Lord Justice Snowden, what was the mistake?
So the mistake was I made the road point. The second point we rely upon is that the boards did not know that their assets could be appointed out to charity. They were entirely unaware that that was an option.
That was under the Nevis arrangements, wasn't it? Or was it always the case?
I think that's all. I think that was a term of the original Trust 1 as
I don't
well.
think the judge makes that finding.
No, he doesn't. But the trust was sold on the basis they were identical. It was simply a shift of jurisdiction. It turned out there were one or two sentences that changed, but certainly it was sold to the Boers on the basis it was nothing other than lifting it from one jurisdiction and putting it in the other.
The fact
so it's the same.
That the assets could be appointed to a charity.
Yeah.
That doesn't seem to have featured in your closing, at any rate.
Well,
as being a relevant mistake.
It finds its way there, but I can take your lordship there if you.
And the judge certainly doesn't seem to regard that as being a relevant mistake.
I accept that. Yes, so 190. So 190. So the passage we were looking at before, which says loss of formal control. So this is starting at page paragraph 188 of the judgment.
Yes.
And that's where it comes to the and then under that 195 is the end point, is the appointment out.
Yeah.
So that is what they didn't know, and that's what he finds at 190. Whether it had an understanding of the implications of this loss of control.
Yeah.
So we say that they can be mistaken as to the implications of the loss of control. See, we say that he drew we said there's no distinction between loss of control and the implications of loss of control. They're the same thing. So, I showed you before from the wealth management report that the Boers thought that they would maintain control. And that they would maintain that control despite putting it into a trust. That's what they were told by ACC.
Well, that I understand, but
Yeah.
you made a separate point about whether the funds could be appointed out to a charity, and I'm struggling to see that in your pleading anywhere.
My lord, the pleading's so long that, sorry, me looking for it now is probably
Right.
not going to, it's not going to assist us, is it?
Yeah. Right.
So I think they're. I haven't shown you my Lord Snowden was looking for the to be shown the parts from the transcript. I don't know whether that's.
I mean, to matter of you, we sort of drifted quite quickly onto ground 4, and we went rather fast, I thought, over ground 2.2. I mean, I'm not requiring you to do that, but my understanding of your case under ground 2.2 does seem to turn to a very large extent upon the employee position. Is that right? I think
Yes. Two parts, yes. Two parts. But yes, one of them is the employee position. Yeah.
And the other part is?
The other part is when the reassurance is given to us by our solicitor. So whether if a solicitor, if we have concerns about the documents, we ask the solicitor whether this is proper and whether this is a lawful thing to do, and the solicitor says yes, then it's difficult to see how we can then be found to be intending to dupe the revenue. That's the point. That's the 2 points.
Well,
yeah.
The answer to the second one, which the judge gave, and which I think most people would give, is just because the solicitor says to you something, it doesn't automatically follow that you can ignore what is blindingly obvious to an honest person.
And the question is whether, yes, we say that it's not if you look at it in context, it isn't blindingly obvious to an honest person.
Right, well, that's why we need...
Sorry, yeah.
Yeah, so, but the mere fact that the solicitor says to you, do X, doesn't mean that a person can say when they do X, that actually I was honest. In other words, the solicitor says to you, look, I've got a document that needs signing here by you and somebody else. I can't get hold of somebody else. Why don't you just sign his name?
But this is far more nuanced than that,
okay.
because they've given their solicitor instructions. The solicitor,
I think that's why we need to get more specific in it. I think that's coming on to the first of the points, which is it seems to turn on an assertion that the judge should not have found that your clients must have understood that the documents were a fiction, a false.
Yes.
And that he ignored, so that when the judge said, for example, at paragraph going in the
C2,
bundle,
isn't it? Yes.
yeah, going in the core to 217 C, either C2 or C3 actually. We haven't really looked very much at 3, but the judge says the Bhaur family would have appreciated that the bulk of their property, the estate, was not only being transferred into a trust, but into a trust for employees that their newly incorporated company did not have. I want to come back to that in a minute.
Yes.
The essential absurdity of transferring considerable wealth into a company remuneration trust for employees the company did not have and did not propose to have cannot have escaped Mr. Bhaur. He would have known it was a fiction. So in other words, I mean, can we just look at that, for example? I think you disagree with that.
Yeah, that seems to be, that's what we think, that's the only example that the judge gives of this. The reason for the finding is because he knew that this was an employee benefit trust and that there were no employees.
I mean, there are other similar paragraphs in the judgment, which, but I mean, so for example, I suppose 159. And the footnote where we've been and we've looked at the footnotes, but your criticism, is this right? Your criticism, and this is where it does get more nuanced about whether this is a trust for employees or a trust for non-family employees, or what?
Yeah, so Mr. Bhaur's evidence, repeated evidence, and it was in his witness statements, is that he thought at this stage, i.e. up to March 2007, that he was an employee, and therefore he and his wife could benefit from the trust.
Right, well, this is where...
So therefore there's no disconnect.
Right, you do need to, I mean,
yes.
Speaking for myself, maybe my lords are ahead of me on the game on this, but speaking for myself, I would like to be led by the nose through this evidence with a little care, because I'm afraid it doesn't leap out of the page at me. have been through the I've been through the transcript references and the witness statement references, but I think you do need to do a job on them.
So let me find the right paragraph. So I'm looking at my notes, which have a different paragraph to. So we're looking at.
And you'll need to address what the judge says on page 93.
Paradise.
I'm lost in the paragraph numbers. It's 28 to 3. Sorry, 28 3D. He's talking about what the trust fund says, and he talks about persons employed by the settlor, that is Safe UK, and indeed says clause 15.1 made it clear that persons who participated in the settlement and persons connected to them could not have any part of the trust fund, save that clause 15.3 made provision for potential payment of income.
I think that, well, so far as, let me answer that point. I think the issue about this is that my clients were just given the documents to sign and they were taken away, but they were not. I think the judge makes a finding that that would not have triggered any understanding for them as to the nuance or the point that subsequent study of them, careful study of them, has derived there.
Right, now my lord wanted to take us through the evidence.
So this is the skeleton of paragraph 43.
Yep.
That's starting on page 28, and the references are then at the top of page 29 are why we say that the judge was very taken with the point that there were no that it was a hallmark of why it was an illegitimate and invasive scheme, because there were no employees.
Well, depending what's meant by no employees, because he himself found that there were employees.
But when he comes to this,
got to be quite careful about that. So 15.2 is the finding that Mr. and Mrs. Bhaur were employees.
yes.
And then there are references to there being other employees. So we were just looking at 28 3D, all the employees, and there are 1 or 2 references elsewhere in the judgment which escaped my mind just now.
Yes, and also the evidence he heard about I think straight after the lunch break, Lord Snowden was referring me to the emails which happened very immediately after, after the March scheme, when there was debate about non-family employees.
Yeah, so that's the footnote 82.
Yes.
Yeah. So when he says no employees, he doesn't mean literally 0. That can't be what he means. Presumably what he must have meant would have been no non-family employees intended to benefit from the EBT.
Yeah. And we say there's nothing in the document, any of the documents up until March, on any basis up until March 2007, that would put my clients on notice of that point, i.e. that it says non-family employees and the trust is intended for them, not for you, Mr. Bhaur. So that when he reads the documents that are there, there's nothing that's going to put him on notice that there's a problem with, which is what the judge finds to be the problem at the paragraph we were just looking at the end of his judgment. So 217, 2C, 2 and 3. The essential certainty of transferring considerable wealth into a company remuneration trust for employees the company did not have. And that's the point, is that the point that Mr. Bhaur made repeatedly, and I'll show you the passages, is that he thought he was an employee. So what he thought he was doing was transferring his family wealth into a trust for employees when he was an employee. So there's nothing, you call it a red flag, or nothing absurd about that. because that was what he said his understanding was. So when he sees the, and that's what the the judge doesn't deal with that. Certainly, none of the passages we've seen does the judge say the express words, which is what the evidence that was given, that Mr. Bhaur thought he was an employee at this point in time, and that's what we find in the references if we start at the supplemental bundle 1 at page 38. So this is day 1, this is the examination in chief of Mr. Bhaur Senior.
Sorry, give me the page again, sorry.
So 38, so supplemental bundle
Got it.
1, page 38.
Yeah.
Sorry, this is a transcript.
Yeah, the transcript, yes. So there's a question from Mr. Anderson just below E. And the end of the...
Who were the staff? Yes,
who were the staff? And he says, myself, my wife, Jacinda, daughter-in-law, Chanjit. So he clearly thought the staff or the employees were those family... page 41. So this is looking at the documents. This is
all right, but sorry to ask a question that's been asked before, but given you've asked this page, I mean, we see at the foot of 38, Mr. Anderson asks, when did you first learn from Mr. O'Toole that he needed non-family staff? Answer, it was in May 2007. And I take your point, that's after the date, I understand that. But subject to that, the question remains the same, which is Mr. Bhaur never suggested that upon learning that, he went straight back to Mr. O'Toole and said, what on earth is this going on about? You sold me a pup. This is not what I bought. This is only 2 months later.
And I think my answer to that earlier is the answer, which is different between whether you have to have staff and whether they benefit or not. There's a difference between them. So they could be staff, they could be potential beneficiaries. Whether these are the sole recipients, which is what eventually was the recipients of your wealth. So that you're the handyman and you get hundreds of thousands of pounds, or you get appointed out to your properties.
Only because of the Barker and Baxendale point. If Barker and Baxendale had gone the other way, then it would have worked for the subsequent generations.
Yes, and these employees would have been potential beneficiaries of the trust, but would have one would anticipate it might have received nothing.
Indeed so.
So this isn't a point that shows it didn't work. This was just, as I said earlier, that the thought given by Mr. Bhaur was he bought this scheme. His lawyers were telling him that it worked better if he had some non-family employees, and he therefore arranged his business affairs to employ people to do tasks that previously that he might have done himself or other members of the family, because he thought that's perfectly proper. There's nothing illegitimate about that. What would be unlawful would be if you said you had Mr. Smith, as I said earlier, and Mr. Smith wasn't employed, but he did employ people who did real work for him, because that he was told that would help the scheme work. Not that anybody would be duped, they would be employees and the revenue would be told, I have employing Mr. Smith or Mr. Jones, and that would be a truthful representation. So the next part I was going to take is page 41, which is so just below F, Q, he says, he says, if you were asked who were the current, past, and present employees of the group of companies of the business, who were the past and present, he gives the same answers we saw a moment ago. And where it says, consider the staff incentive needs of the company, who were the staff of the company, we thought it was us. We thought it was us because we were the employees. And this is why, we didn't doubt anything, because there were no outsiders and we were the only 3 people working for the company.
Yes.
So they asked the question, and they gave a clear, most position, a clear answer to it. The same.
And this is a reference to the document of the 2nd of Feb referred to at paragraph 143 of the judgment, I think, isn't it?
Yes, and so this is an so I would call it in time document, i.e. pre-March. Because what's happening here is that Mr. Anderson is taking Mr. Bhaur through the wealth management report.
No, he's taking
on the retainer letter here.
He's taking him through the record of instruction.
Structure, yeah, the retainer letter.
Right.
So that starts at, yes, page 39.
Yeah.
Yes, the previous part was the wealth management report. There's then a further page 51. And this is I think this is at the time that he was signing the documents themselves, the March documents.
No, I think, no, I'm not sure it is. I think what he is dealing with there is the document at paragraph 154 of the judgment.
So I'm looking, so I think, you look at page, so go back to page 50.
Yes.
Then top of page 50, we're looking at the 10th of March deed.
Yes.
And I think he's shown it at the bottom. The question is, I think from the judge, I think, why did you sign it?
Okay, so which document do you think we're looking at then?
I think we're looking at the 10th March document, the trust itself.
Okay, so where's
I might be wrong about that.
No, you may be right, but where's?
Number of documents. Sorry, so look.
That's the settlement, isn't it? 10th of March.
Yeah. And then 15th of March, ACC. Sorry, Mr. Then says a number of other documents. Sent letter to the client dated 2/16. First letter wishes. Yeah, this is the.
Sorry,
this is the pack. This is the pack that they signed.
Okay.
That gave effect to the trust. So it's on.
I'm trying to take a note here, right?
I'm sorry, my lord.
Please, can you tell me where in either the judgment I can read the document he's been cross-examined about, or find it in the bundle?
Yes, I think these are the transactional documents themselves, which are, you won't find it in the bundle. You'll find it. These are the documents that are referred to at page 15 of the judgment, so page 54. This is the establishment documents. It's the paragraph 28 documents, which are the sub 3, the trust itself, and sub 5, the and the letter. I think the reference somewhere to the letter of wishes.
So this letter, he talks about a letter.
So the letter of wishes is at 5B.
Right. Okay.
So sub 5B. That's what's referred to next to page 50, 50 big B. It says there's 4 separate documents. First document is the letter of wishes. So the letter of wishes is what's found in the judgment at sub 5B. Mr. Anderson points out, backdated to the 10th of March, I think they're all signed on the same day, replete with language of EBT.
No, that's fine.
Okay. The judge rightly asked for Mr. Bhaur's comments upon it. The judge then reads it. And then the judge asks him right at the bottom, why did you sign it? Bottom of page 50. And top of page 51 is the clear answer. Well, we felt we were the only employees. So if there is any benefit, then it will come to us. And obviously this is the deal. This is the deal with it. So next document, I'm not sure quite what the next document is. This is the clip of 4 that's sent at that time. Judge says, having read it, were you happy to sign it? Did you not think what is it going to? Mr. Bhaur answers, because we always felt that we were the employees. And every 12 months, if you had to do, you could command something beneficial to us and no third party.
So essentially, his evidence was that he thought that Mr. Bhaur's wife and daughter-in-law could, every year, get something out of the trust.
Yes.
Right. Yep.
There are other references. That's the most helpful in a sense because that's evidence at the time of the operative time. That there is then other examples of it. The next one that I'd note is at page 78.
I hadn't spotted this before, but it perhaps goes back to one of your earlier grounds, but one of the two, ground 2-1, I think. But at page 52 of the transcript, between D and E, the judge specifically raises the question, for whom is this intended to be a paper trail? Is it intended as something one can produce to a tax authority? So, right at the outset of the evidence, the judge made it clear that that was something, that question that needed to be addressed.
It's just, I think as I accepted in submissions, it practically wasn't put. And here again, this unfortunate, the passage you're looking at here was Mr. Bhaur is in the witness box. So there's an unfortunate discourse with hindsight between the judge and Mr. Anderson, whereas turning round and saying immediately afterwards, and Mr. Bhaur question would have given him the opportunity to do it. Unfortunately,
but if Mr. Anderson felt that the matter was not adequately covered in the existing evidence, he could turn straight to his client and say, "You've heard the question. What's your answer?"
I think I accept. I think that's the word unfortunate, but it doesn't detract concepts from the point.
Yeah, 71. We're going to.
So 78.
78.
Now day 2. Just trying to make sure the content. We're now moving on in time. So these are documents which came about after March. So they're less force to the point for the appeal. But again, you can see starting at the bottom of page 77, the judge says, "Mr. Bhaur, perhaps I can ask you this. Looking at the second paragraph in this letter, your instructions to us to build a staff incentive vehicle was not motivated by taxes, but purely by desire to build a staff incentive vehicle." Now that really, is that a fair description of your instructions? Well, my lord, we were the only employees of the company when we had the trust from ACC.
Sorry, I'm sorry. I
My fault.
I lost the page number.
So 77.
77. Sorry. 57. Sorry.
The bottom of 70 is it's the judge's question, the effectively question at the bottom, 77, and the answer at the top of 78.
Yeah, and the letter that we're looking at is.
I think the letter. So I don't think the letter's referred to in the judgment. We're just looking at time. I think this is clearly after the. I think this is looking chronologically. This is moving towards the end of 07, beginning of 08. I think.
Oh, isn't this the document? This is the document at page 150, paragraph 157, isn't it, of the judgment? Or is it not? Maybe it's the same phrasing.
It suggests it was 2007 by the answer of 13 years ago.
Well, I'm just looking.
77.
If you look at the paragraph 157 of the judgment,
yes,
the bold text at the bottom of page
what's read out.
103 of the core bundle
Is what's read out.
is what seems to be read out. So
Yes.
the second paragraph of the letter.
Yes, I think it's the.
Yeah.
Yes. So the let me. Yep, the reference is 290. Check it out, that's true.
And the judge does say, doesn't he, as part of his, the judge does say as part of his, yeah, I mean, your point is that staff incentive vehicle could include something that incentivises
The board.
Mr. or Mrs. Bhaur and the daughter-in-law.
Yes. Therefore, there's no obvious red, not a glaring red flag that shouts and screams at Mr. Bhaur before he signed it that there was something amiss.
Well, the judge takes a slightly different
Yes,
point,
that's what he does. But he,
which is that the motivation of this whole thing was plainly tax, not building a staff incentive vehicle.
but the two are not necessarily. So
I mean, it's a quite odd incentive, isn't it, that assets which you currently own, 100%, which you've got access to, are put into trust to create, apparently, an incentive for you.
which lawfully can save you paying inheritance tax.
Yeah, but that's not the point.
Yes.
The point is it incentivising you qua employee, as an employee, as a member of staff, or indeed any other member of staff?
The payment of monies to you might incentivise you. I
Well,
I understand it's circular.
But before the whole
Yeah.
structure's put in place,
It is yours.
it's yours anyway.
It's yours. Yes.
Why is an incentive to you
But
described as to describe yourself as staff or an employee to be incentivised by receipt of some part of assets which part of the whole structure you owned anyway?
well, his family didn't, but sorry, his children didn't. The other employee,
His
daughter in. The other family members who worked for the business had no interest at that point, arguably. They had an anticipation of an inheritance, but no more.
I mean, that's why in paragraph 100, at the end of paragraph 157 of the judgment, the judge says the point that Mr. Bhaur's trusted advisors were telling the scheme was not motivated by tax concerns, which was plainly wrong, and that the objective was to build a staff incentive vehicle, which was not Mr. Bhaur's intention. I mean, the judge is right there, isn't he?
Yes.
So why doesn't Mr. Bhaur then say, if that's suddenly, why doesn't that prompt the realisation, Mr. Bhaur, hey, just wait a minute, is that what's happened here 2 months ago? Oh, sorry, a few months ago. I mean,
They've now signed up and paid the money.
He doesn't say, hey, this is all a terrible mistake. This is not what I intended.
Well, what did he? But at that stage, whether that's not fundamental to the, there might be a slowly sinking realisation, but that point isn't a fundamental point. His solicitors he's asked his solicitors for some advice, and they have said to him, "You do this. This is how you lawfully achieve the goal. You satisfy your instructions. Dynastic inheritance tax saving." So that's a narrow point. They might have a cumulative effect.
Yeah.
And there might be a penny dropping eventually. That might be a point, which the judge didn't. There might become a point in time where that's a good point, but it certainly wasn't a good point in March 2007, and even at this very early stage. It's worth then having maybe page 94, 95. If you go to 94, this is Mr. Ash's initial cross-examination, so it has some. We're back in time, so to speak. 94, you can see at 94, this is Mr. Ash. If you go to the top of page 95, so let's have a look to the bottom. So this again is looking at the looking at a summary. I think you can see that at page 94D. Okay, at bottom of the page, and here's the question. So the first one I want to highlight is the 8th bullet point. Up from the bottom, it says those holding 5% or more of the share capital of the company are specifically excluded from benefiting from the trust, i.e. it's only for genuine employees. Do you see that? Yes, I do. Good. Now, what I want to ask you is, what did you understand by that? Well, we were the only employees at that moment, and there were no other employees involved in the company. So this is what we understood. The benefit is for us. Follow up, couple of questions. Who said we were the only employees? Yes. Who do you mean by we? Me, my wife, and my daughter-in-law.
Okay, so again, can I just ask, where is the document?
So this is the doc. I don't think this document came to the got into the judgment. This was an advice document that had bullet points in it. I don't think it got to the judgment.
So,
oh, sorry, is it? No, it might be actually. So let's go on. Sorry.
can you help me? How does this evidence that you're relying upon now square with the evidence that your client gave in his witness statements? So if you take supplemental bundle 2, and we go to the first witness statement at page 33, paragraph 37.
Yes.
On or around 21st February 2007, so this is before the critical date, third defendant, Mr. O'Toole, attended my office again, discussed the workings of the trust, he advised me as a matter of good order how to incorporate the business of the trust. We were advised that for the trust to be efficient, it was necessary to have 2 full-time but unconnected to the family employees. So that's the first statement. Then he elaborates in his second statement at page 65, paragraph 33, and now he's got the right date. 17th February 2007, Mr. O'Toole attended my office again for a breakfast meeting. He signed on the documents, discussed the work of his trust, advised me as a matter of good order how to incorporate the business into the trust as per his letter of advice dated 5th February. In addition to this, we were advised we should have at least 2 non-family members. While we were reluctant to do so, we agreed to their advice. Following that meeting, we set about employing an office manager and a maintenance manager. So the evidence in the 2 witness statements is that in mid-February, he's advised there have to be 2 full-time non-family employees, and that was action.
Yes, subsequently, yes. I think yes, but that doesn't go against the point that they thought they were employees as well. So the money, the wealth, they could benefit from the wealth that they were putting into the trust. The point we're dealing with at the moment is the judge's absence of, or the paragraph which is, well, simply, Mr. Bhaur, you should have been on notice that this wasn't, that you were mistaken, because you signed up to an employee benefit trust when you said you had it. And his answer to that is, no, I thought we were an employee. Therefore, we say that's a bad.
My Lord, if I might assist my learned friend, I just want to be aware that I submitted a supplementary skeleton on Friday based upon late receipt of the replacement skeleton from the appellants, and there I think I stated that, brought to the attention of the court these 2 paragraphs. It will be a matter I will come to in my submissions, but if I could take you to page 311 of the first supplementary bundle. So that's page 311. And if you go to the bottom of the page, so G and H, I believe this is Mr. Ash cross-examining. It says at the top at B, Bhaur, but in my submissions I'll say I think probably the answer was actually from Mr. Bhaur, the father. But at G and H, this point is raised, and in fairness to the appellants, Mr. Bhaur, I believe, states that in actual fact, I think the wording at H, then over to the top of the page of 30312, seems to be he's suggesting that he made a mistake, and that in actual fact, in his witness statements, the statement should have been May, not February. But I just wanted to bring that to your attention, my lords, just so that if you got the impression from my supplementary skeleton that this matter wasn't, I think I said, I don't think it was undisputed, but I think Mr. Bhaur did try to clarify
Yes.
at that stage. So I just wanted to make sure that
Yes, thank you.
my lords were not misled.
Thank you.
And so then the final reference, just 3 pages, again, it's helpful because it's Mr. Ash, page 305.
205.
305.
305.
This is something I think we were looking just earlier than this a moment ago. I think this is the retainer letter, or the summary of work carried out that Mr. Bhaur has been taken to. You can see that at the top, or just before B. We create a remuneration trust. Then the question goes, D, it's only for genuine employees. Right, you see that. No, at the time we were the genuine employees.
Yeah.
So that was the evidence that supports. So we say therefore, just simply, there seems to be a lot when we set out that I think there's 5 different references in the judgment where the judge put a lot of weight on the fact that it's an employment benefit trust without any employees. That should have put Mr. Bhaur on notice of that. And then this evidence shows the reason why that didn't put him on notice, that there was a difficulty with it, because he simply thought that he and his wife and his daughter-in-law were the employees and could therefore benefit, and that the stage of their knowledge at that stage of an employment benefit trust and how it worked, that is a proper explanation as to why that issue didn't cause Mr. Bhaur concern. There was secondary, the other parts of the main parts of the transcript that are referred to in the amended skeleton argument are the bits that make good the proposition that Mr. Bhaur trusted his solicitor. I suspect that's a less startling proposition, but the references are there. I can take my lords to that if thought appropriate, but I suspect that's.
Well, it'd be surprising if he didn't.
It's surprising if he didn't. But the point we make is that that's what the judge sort of found. That's clearly the position at the beginning, as you would expect. And sometime along the road, it might be that he had good reason to doubt that. I mean, and the question is, had he reached? The judge doesn't make the finding as to whether he reached that point by the middle of March. And on what we've seen, there's no good reason why that early on in this he would have got to that place.
I mean, just to be very fair to the judge for a second. To be fair to the judge.
Yes and no.
The point you're now criticising him for didn't feature in the closing at all, did it?
I think I looked it up at my lunch break. I think it did, or maybe it's because we didn't. I think there was no appreciation. Might be because there wasn't appreciation on our part because of all this evidence that it actually was an issue. So in a sense, the judge decided it to put great weight on the proposition that the red flag for Mr. Bhaur was employee, and you didn't have any employees.
Yeah,
that sort of.
I understand that point, but
yes.
Sorry, the point I was trying to drive at is that you never actually identified unsuitability of the trust by reason of employees or benefit for employees as a mistake at all. I mean, we looked at what you said in your closing about the mistakes. You had tax, loss of control, and Mr. O'Toole being dishonest.
Yes.
You never said, you never followed through on paragraph 14 of your points of claim in saying, if you remember paragraph 14, where it was points of claim, where it was pleaded very explicitly, as
yes.
the Lord Justice Lewison pointed out to you this morning, and that was your pleaded point. At no time did the claimants have any intention to need to set up a trust to incentivize or reward employees, and had no employees who could lawfully benefit from a trust. I mean, that's actually contrary to the argument that's being run now.
Yeah, I think.
I mean, that the pleaded case is. There were no employees who could lawfully benefit from the trust, or certainly no employees who were intended to benefit from the trust.
This is the back. Sorry, my lord.
So that's the pleaded case. Then
That's the Baxendale Walker. So that's in effect the Baxendale Walker point, which is that they can't benefit. The family members can't benefit. Therefore, it must only be for other non-family beneficiaries. And therefore, the position today is, after Baxendale Walker, that the sole beneficiaries are these unconnected employees, i.e. non-family members.
At no time did any of the claimants have any intention or need to set up a trust to incentivise or reward employees.
Yes, the point I make is
and had no employees who could lawfully benefit from such a trust. That's talking about exactly what we've just been looking at, about whether when the document said this is an employee incentive scheme, who did you think was going to be incentivised? And Mr. Bhaur's answer was, well, me, my wife, and my daughter-in-law.
And he didn't realise that they couldn't. This, of course, today is they can't.
Well, I'm asking two things. One is, his evidence seems to be flat contrary to that pleading. Because if asked the question now, did you have any employees who could lawfully benefit from the trust, he would have said, yeah, well, me, my wife, and my daughter-in-law. But then the second point is, that point, the paragraph 14A pleading, doesn't seem to have been carried through into your mistake submissions to the judge. I mean, where in the closing submission was this point explored with the judge about the unsuitability of this arrangement by reason of the fact that there were no employees or employees other than family members?
Supplementary fund on page 99. This is where this bit. So this is the case that was closed, 6061. And you can see in the middle of 61, the point we made now was overlooked by the judge's judgment.
Sorry, what page are we on?
So 99 in supplemental 2. This is the
so this confirms what you told me when I asked the question this morning, which is that you didn't close on the basis pleaded in 14A.
No.
You closed on the basis that we see here, namely there was a mistake in three respects: the downside tax risk, of which they were not told, that it was controlled by a rogue, and there was the absence of control. Those were the three mistakes that you closed on.
And to be frank, the reason for the change of the points of claim between then and opening the trial was we had some advice given, some tax advice obtained on our side, which made the point, the Baxendale Walker point, and the fact that it wasn't pursued. So I accept it's pleaded at that, but the main reason for the closings and for me taking you to it is to make clear how the case was presented at the end of it. Of course, there was also quite a significant load of disclosure between the points of claim and the closing. But the judge put weight on the points, but but in essence, the thrust of the case was that which was closed, not that which was which was pleaded. The points we make of consistency is in a sense where we pleaded in the points of claim and pursue it in our closing submissions, and those are points that we were entitled for the judge. That was the case we advanced, and we're entitled for the judge to make a decision upon those. And where he doesn't, where they're opened and closed, we think we're entitled to be critical of that. Except that if we put something in the points of claim but don't close it, then I haven't stood here and said that the judge was wrong to ignore what we put in our points of claim. I think the passage here is a clear example of the point that we're now making in middle of paragraph 61, which is the explanation. You know, we've gone through the transcript, we've looked at it. This was closed, this explanation about what Mr. Bhaur thought. It wasn't a point that suddenly, you know, we attempted to go out to make clear what our position was, and the position that's set out there is the position that I hope I'm advancing today.
Yes.
I noticed the time. I know it's important. It's about the nature of these things that we jumped around a bit, but if there's anything else that I can help with, so I need to deal, I suppose, at some point with the hearing from the third respondent, I suppose.
Yes. Well,
we need to deal with that one.
There are 2 points, I think. One is that point, and the other is a point we've already partially canvassed with you, namely, assuming that you are right on mistake, what relief do you get, bearing in mind that last section of Pitt and Holt and the nature of the scheme into which your clients entered?
So over luncheon, it might be what I probably should show you again that we probably should look at the couple of authorities that are in the authorities bundle where this point has been raised, because the judge in his judgment notes that it's been raised and never pursued.
Yeah.
And it might be helpful just to look at at those examples as a way, as it sort of explains the reason why it hasn't been pursued. And it's tab 4. I think was where. Yes, tab 4, which is the first instant decision of Mr. Justice Morgan in the Van Marie case.
Yes.
I'm sorry, maybe I've had this for a different point. Maybe it's wrong. Yes, that's right. So first of all, this case is helpful because it deals with the 2 sorts of mistake that we got to this morning. The common law and the voluntary dispositions. You can see Mr. Justice Morgan setting that out. But the consideration of this point comes on page 9 of the decision, paragraph 42. And you can see there that this is the very point. And the analogies drawn here with other fields and Mr. Justice and looking at this other fields of related public policy issues suggests that the court would not be expected to withhold relief on this ground, the artificiality ground.
Yep.
So, again, I made the point earlier that HMRC are aware of these proceedings and haven't, in particular, haven't raised that point. What was the raised Pitt and Holt expressly? It was just I think. Maybe I mischaracterised it one line, but it was only a very short letter that just said, make sure that case is provided to the judge. There was no, they certainly didn't in that judgment suggest that this was a jurisdiction that the court should be minded to go. Where's so that was the one. That was the case over the luncheon.
I mean, it's not saying. Sorry, I mean, it's not saying you can't give effect to Lord Walker's suggestion. It's just you can't do it on the facts of this case.
But and I think bearing in mind though, so I haven't brought the laboratoires civière, but I think I think these are cases where there is extirping causa, so some sort of dishonesty.
Yeah,
and the public policy being applied.
It always moved on since then because we got Patel and Mercer.
Mercer, of course, yes. Which well, that's a difficult case. So certainly, if this wasn't a matter pursued below, if it's something that your lordships would want to consider in more detail, I'm quite content to produce a note that at least draws your attention to the authorities that are available.
But is that relevant? Because surely what Lord Walker was talking about was whether equity should intervene. Because what you're asking for is the intervention of equity to assist you in setting aside a voluntary disposition. Whereas ex terpi causa is all about barring a cause of action that you would otherwise have.
Is it, sorry, I put back, is it actually different? Because if but for this argument I would have a remedy and I don't, is there any difference? The same remedy as in Mercer, which is reliance on, so for example, the reliance on dishonest conduct in order to obtain a remedy.
Well, in crude terms, it's common law versus equity. I mean, that's a gross oversimplification, but that's the point, isn't it?
It's a bit like the clean hands doctrine in equity. If you don't come with clean hands, equity may say, well, see your remedies are common law. You won't get anything out of a court of equity. It's not barring your causes of action, it's just withholding relief.
Holding relief, but on that yes. But what we would say is that we came with clean, certainly at the March point, we have clean hands. Because we simply approach a solicitor, we say we have this problem, and a perfectly reputable, on its face, solicitor supported by a QC's opinion, says, and questioned by us whether this is lawful, says it is. So I think that, the issue might be more, I accept, more germane in other situations or further down the line. But on the facts of this case, looking at it in March, then that shouldn't deprive us of a remedy when what we've asked is a exhibition here. There's no point.
Well, I mean, Lord Walker is saying that there may be something less than non-clean hands, but simply if you're engaged in artificial tax avoidance, that's not a no clean hands type or anything to do with Patel and Mercer or anything like it. It's just as a matter of policy. I mean, that's what Lord Walker saying. So, I mean, but it may be if. Okay.
But I'm back to the more general, and there might be some artificiality about it, but that all these mistake cases do have a backdrop of a tax issue. And there are trusts or family things that are set. I accept this is a narrow. I accept this is slightly closer, but the background to all these sorts of cases are similar facts, aren't they?
Well, which is not necessarily. The background to a lot of the cases is that somebody enters into a gratuitous transaction which has an adverse tax consequence, but it wasn't supposed to be. Wasn't a quote artificial tax avoidance scheme.
And the question of this one is, yes, so I'm bringing it back to the subjective point, which is, subjectively, my clients didn't know that. If objectively, your lordship's point is, objectively it might be, we would say that the objective, that equity should look at the subjective position of my client as to whether he's in terms innocent. The innocent victim of a rogue, which is where the judge starts his analysis at paragraph 15. He then moves away from that. But
well, I
that background is different. If
you don't need to go that far, do you? Leave the rogue out of it for a second. Somebody engages in what they know is an artificial tax avoidance scheme. It doesn't have the consequence that they hope for because the revenue deny its efficacy. And the consequence is that they actually suffer a big tax hit. Nobody's been dishonest, it just didn't work. But it was an artificial tax avoidance scheme. On one view of what Lord Walker is saying, equity just should not intervene to help somebody who has made a mistake in that scenario. They've got lawyers, they can sue their lawyers, sue their accountants, whatever, but equity shouldn't get involved.
And before you answer, can I point out that that's exactly what Lord Walker says, actually, when you look at it. He says, in some cases of artificial tax avoidance, the court might think it right to use relief, either on the ground that such claimants, acting on supposedly expert advice, must be taken to have accepted the risk that the scheme would prove ineffective, or on the ground that discretionary relief should be refused on the grounds of public policy. So he gives two possible grounds, and the first one is the one articulated by my lord.
But the first one isn't my case.
It's the case against you.
But no, sorry. In effect, the scheme would prove ineffective. So the narrow point here is that the three grounds that I closed it on aren't that the scheme didn't work. It was ineffective as a piece of tax planning. I'm not running the point that was abandoned in the particulars of claim. That's what that point would be, which would be that the scheme I was sold didn't have the tax consequences that were sold to me. My case here is more nuanced than that. It's the three grounds of mistake that are set out, which are different to that, and go to the character of the scheme as opposed to simply its effectiveness for tax. Yeah.
I think, Mr. Mitchell, we're going to have to leave it there for today.
Yes.
As I mentioned at the beginning, we're going to have to change courts. I'm told it's going to be court 67, which is one floor further down. And we will resume again at 10:30. You'll need to deal with the question of whether we hear Mr. Appellant at all. And if we do decide that we will hear him, we will then hear him and be all right.
And of course, we'll find. I think there was 2 documents. Probably.
I'm sorry?
There was a couple of pieces of homework that I should.
Yes, indeed. And we've asked you a lot of questions, so if you want to answer them tomorrow morning.
I should try not to, but I certainly will handle them.
All right. Thank you very much.
Thank you.